So I've just thought, I don't know, do you want to have a little read with me? Okay, so this is from Tati's side. Should we do the introduction? Fuck the introduction, I reckon. Clarification, my kind of scene. Since plaintiff's lawsuit was filed less than 3 months ago, defendants have made dozens of public statements regarding this case on Twitter, Facebook, Instagram, and YouTube. Below is a non-exhaustive list of dates on which defendants address this case on social media. Whoa. October 31, Twitter, and 2 YouTube videos entitled It's True About the Westbrooks and I Will Be Okay, and This Channel Will Keep Going. November 1, Twitter. November 6, Twitter. November 8, Twitter. November 9, YouTube, My Story, My Statements, and My Mistakes. November 11, Twitter. November 25, YouTube. Update on lawsuit responding to criticism, how to give back. November 29, YouTube, Am I okay? December 9, No one deserves anything. December 27, Venting our frustrations. December 29, all of this needs to stop. January 7, Twitter and YouTube, the worst day ever. January 8, Twitter. January 15. This is just January 15, YouTube. He's evil. Trisha Paytas is terrified of Jeffree Star over this. January 16, YouTube. This is really bad. She's done. January 18, Twitter. As this case involves defamatory statements asserted on social, plaintiff's counsel, Michael Saltz, has used his personal Twitter account to seek out witnesses and information relating to the plaintiff's claims to refute defendants' numerous unprovoked prejudicial, am I saying that right? Prejudicial public statements about this litigation. Oh my God, it's nearly February. Fuck, it's nearly February. I still can't believe it's 2021. In mid-January 2021, Mr. Saltz and several of plaintiff's witnesses were subjected to widespread hacking of their personal social media and email accounts, as well as vicious online harassment, including doxing. On the morning of January 18, 2021, a federal holiday, Mr. Saltz alerted Mr. Brown to urgent hacking issues and requested a telephone call to discuss the matter. The two exchanged several emails, but no telephone conference occurred, nor did Mr. Brown request one prior to filing defendant's motion. Okay, this is their argument. A. Defendants failed to make a meaningful effort to confer with plaintiff's counsel prior to filing the motion. This court's standing order for all civil cases requires that the parties make a meaningful effort to confer prior to filing a motion. Further, the parties should provide for at least 3 business days between attempts to confer and a motion's filing, and shall explain their specific efforts to comply if contact was not successfully made. Motions that do not comply may be summarily denied. In one of Mr. Brown's emails on January 18, 2021, he stated, quotes, I am skeptical of your allegations, but they should be aired in front of the judge. I also have concerns that I want addressed. I don't think we can get her attention on a holiday. Perhaps we should send an email or something today. No attempt was made by Mr. Brown to substantively discuss the matter. Defendant's motion was filed with the court at 5:53 p.m. that same day. I want to see the footnote for that. Oh. Footnote number 11. where it says no attempt was made by Mr. Brown to substantively discuss the matter. Down here it says Salt's declaration. Notably, Mr. Brown ignored Mr. Salt's earlier request for a telephone conference to discuss these issues. Why is he avoiding calls and he only wants to talk on email? Maybe because Mr. Brown is Katie. No. Don't be a silly Billy. B. Any constraints on plaintiff's counsel's use of social media are unwarranted. Oh, I want to see the footnote for number 13. Number 13, what you got. Curiously, defendant's request for this court's assistance to restrain plaintiff's counsel from litigating plaintiff's case largely on social media directly contradicts defendant's position that this court has no jurisdiction over this matter as set forth in their pending motion to dismiss. Oh my God, can we please do a high five to Saltsy? Boom! I like that, mate. Yeah, you came in there, didn't you? Defendants failed to establish how Mr. Salt's limited statements to his relatively small group of followers on Twitter have somehow created a massive social media circus surrounding this lawsuit. Defendants acknowledge that plaintiff Tati Westbrook is a prominent social media personality, also in quotes. Additionally, Miss Paulson has over 2,000 more Twitter followers than Mr. Salt's and has a YouTube channel with more than 135,000 subscribers. Ms. Paulson has continued to address this case to her followers on both Twitter and YouTube, among with social media venues. Since plaintiff's complaint, moreover, the filings in this case are publicly available and closely followed by parties, thousands of supporters and detractors. Additionally, defendants have failed to identify any statute, rule, or case of law that prohibits counsel from seeking witnesses and information relating to plaintiff's defamation case on social media. In fact, the Washington Rules of Professional Conduct expressly permit counsel to publicly discuss a case in which the statements will not have a substantial likelihood of
prejudicing, prejudicing,
prejudicing,
prejudicing,
prejudicing, you're prejudicing us all. In fact, the Washington Rules of Professional Conduct expressly permit counsel to publicly discuss a case if the statements will not have a substantial likelihood of materially prejudicing an objective proceeding in the matter. Specifically, counsel may state inter alia a request for assistance in obtaining evidence and information necessary thereto, and a warning of danger concerning the behaviour of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. Further, counsel may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Mr. Salt's inquiries and statements on Twitter related to this case are limited to seeking witnesses and information, warning of danger about the widespread hacking and harassment of witnesses, counsel, and other parties to this case, and clarifying defendants' misrepresentation and or statements made on social media after the complaint was filed. None of Mr. Salt's limited public statements have a substantial likelihood of materially prejudicing. It's not prejudicing. this matter. If anything, Mr. Saltz has been trying to clarify defendants' unprovoked, prejudicial statements against plaintiffs. Moreover, plaintiffs' counsel never publicly accused defendants of hacking or threatened defendants or defendants' counsel with criminal prosecution. Plaintiffs' counsel actually informed Mr. Brown that widespread hacking of his personal social media and email accounts, as well vicious online harassment of witnesses and hacking of witnesses' social media and email accounts, was occurring, and that a forensic expert had been engaged to track down the hackers who were making serious criminal threats. Finally, while defendants have not formally requested a restraining order prohibiting plaintiff's counsel from exercising his First Amendment right, if this court considers a prior restraint against plaintiff's counsel, plaintiffs respectively request a full briefing schedule. Additionally, if a prior restraint is ordered, it must also be applied against defendants and defendants' counsel. Boom, bitch! Can anyone hear the bombs explode? Boom, boom, boom. I hear them going off like fireworks. Like fireworks. Okay. C. Plaintiffs move to strike Mr. Brown's declaration. Pursuant to LCR 7G, plaintiffs move to strike Mr. Brown's declaration in support of defendant's motion, as Mr. Brown's statements about the referenced screenshots and emails are misleading and or irrelevant. For example, Mr. Brown's statement in paragraph 4 states, dun, 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 dun. What did you say, Mr. Brown? What did you say? Mr. Brown said, below is a screenshot from a video on a YouTube video that Mr. Saltz has promoted on his Twitter account. However, the reference screenshot fails to show that Mr. Saltz is promoting a YouTube channel. The screenshot is not even from Mr. Saltz's Twitter page. Instead, it is simply a screenshot of a YouTube channel at issue. Notably, the reference screenshot captures the YouTube channel discussing defendant's motion to dismiss, which was filed and made publicly available on December 2nd, 2020. I mean, Jesus, Katie. Click, click, click. What have we been telling you? Those wheels in your mind, they've got to go round. They've got to go round for your mind to work. In paragraph 5, Mr. Brown states, below are screenshots of just a few of the tweets Mr. Saltz has posted publicly to accuse Miss Paulson of the crime of hacking. However, however, the reference screenshot, you know what? Is Mr. Brown Katie. This is what she does. She shows shit on the screen that has nothing to do with what she's talking about. She would have been so crap at writing essays, wouldn't she? And here's my evidence to support that fact. And it's like, what the fuck has that got to do with this? However, the reference screenshot does not show Mr. Saltz publicly accused anyone in particular of hacking. Instead, the screenshot shows that Mr. Saltz recognized a familiar email address used in the hacking attempt. The next screenshot does not mention any names, nor does it contain any alleged accusation against Miss Paulson. The following 3 screenshots on pages 7 and 8 of Mr. Brown's declaration also fail to mention any names or contain any accusations of hacking against Miss Paulson. Yeah, because she can't fucking comprehend anything. I mean, gosh, you'd think Mr. Brown would know that his defendant is mentally unwell. What she thinks she reads, like how she interprets that, are 2 fucking different things. In paragraph 6, Mr. Brown states, attached as Exhibit A to C are true and correct copies of the emails Mr. Saltz sent me this morning, accusing Ms. Paulson of federal crimes and demanding that I explain my involvement. First, Mr. Brown failed to provide the entire email chain between counsel to the court. Second, there is no evidence in the email chain of Mr. Saltz accusing Ms. Paulson of federal crimes. Instead, Mr. Saltz alerted Mr. Brown. One of the hackers stated on Twitter that he or she was hired by defendants to hack into Mr. Saltz's email. Mr. Saltz also requested that Mr. Brown take all steps to preserve any and all evidence so that a full forensic investigation could be completed. Conclusion. Plaintiffs agree that court intervention is appropriate at this time, but disagree that it is due to the actions of plaintiffs' counsel. That's it. So I just came here to get a date for a video that I was uploading, video that I forgot to upload. It's a great series. There's so many fucking videos that I haven't uploaded. Anyway, while I was here, I was like, oh shit, there's the minute entry for the proceedings that were held, Let's have a look. So this was posted on the 2nd of February. God, it's the first time I haven't had to read in an American date because basically it's an Australian date, the 2nd of the 2nd. We do the day, then the month, then the year. And you guys do the month and then the day and then the year. So it's a little bit confusing, but I didn't need to do that. It's great. Okay. The court held a hearing on defendant's motion for status conference. After hearing argument of counsel regarding allegations of abusive and inappropriate use of social media made by both sides against the other, the court declined to issue a restraining order limiting counsel's or the parties' use of social media. However, the court reminds the attorneys in this matter that they will be held to all rules of professional conduct and relevant to the dispute, in particular, Washington RPC 3.6, materially identical to Californian rule of professional court, 5 to 120 A in brackets, whatever that was. That a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have substantial likelihood of materially prejudicing. Oh my God, did I say it? In an adjudicative, in an adjudicative proceeding in the matter. Counsel is cautioned that abuses of social media outlets that test the limits of this rule will not be countenanced. Will not be countenanced. Web search. Tell me how to say it. Countenance.
Countenance.
Countenance. Oh my God, look at me. This could be my job. I could read out how to pronounce things and then I would learn. Let's do it one more time.
Countenance.
Countenance. It really does remind me of like continents, but thank God it's got the U in there, right? Let's apply that to the situation. Counsel is cautioned that abuses of social media outlets that test the limits of this rule will not be countenanced, tolerated. Scroll down and it says that on the 3rd of February, Katie made a transcript request for the proceedings. Yeah. And then the judge replied on the 4th and said, Notice of filing of official transcript. Parties have 7 calendar days to file with the court a notice of intent to request redaction of this transcript. If no notice is filed, the transcript may be made remotely electronically available to the public without redaction after 90 calendar days. Transcript may be viewed at the court public terminal or purchased through the court reporter transcriber before the deadline for release of transcript restriction. After that date, it may be obtained through PACER. Information regarding the policy can be found at this website. To purchase a copy of the transcript, contact the court reporter.